don't know where Champlin is, a lot of people don't. It is in Hennepin County, and it's in that northwest corner, kind of between Anoka and Brooklyn Park, Brooklyn Center, Maple Grove, kind of up in that area. So my wife and I practice together. We are constantly asked, how's that? And it actually is a really good thing. It's something that, thank you, something that we've been at now together for 17 years. And we both went to William Mitchell, and I've been out 20 and she's been out 22. So I understand from a big picture standpoint, most of you that are here today aren't family law practitioners, may not have any interest in family law whatsoever. But this case is one that is particularly interesting because it brings together a host of issues and norms that have developed over the last 10 years, and even beyond that, but in particular the last 10 years, where in the arena of family law, we've seen changes with regard to what the presumptions are concerning custody and parenting time schedules. We've seen a change in the child support statutes. We've seen a change in alimony no longer being tax deductible or counted as income. There's now a revised best interest standard that applies. So one of the privileges I also have is I write monthly for Minnesota Lawyer, and I write their family law column, keeping folks who hopefully read it up with what's developing, what's happening. And as part of that, I've been able to sort of prognosticate and think a little bit about where are we going. And I've routinely said in that article, in that column, that the 2010s will be remembered as a real decade of change in the area of family law, same-sex marriage, and lots of different movements towards alternative dispute resolution. Going forward, I think one thing that may come to light, I'm just predicting, I don't know, is that we'll do away with labels involving physical and legal custody. It seems that every judge and mediator that I encounter say the same thing, and that's that the labels don't really matter. And they don't. I mean, when it comes to raising a child and caring for a child, it really is about the day-to-day care. It's more about what are you doing, how are you working together, rather than what label do you have, what badge do you put on your shoulder. Another change I foresee is perhaps some changes to our paternity statutes where, for the last 40 years, there's been just an unequivocal presumption that mothers are designated sole physical and legal custodians of children that happen to be born outside of a marital relationship. And certainly there's a time and a place for that sort of presumption, depending upon the nature of the relationship between the mother and father of that child. But with this emergence of a trend towards cohabitation and what seems like an unwillingness on the legislature's part to embrace that as a cultural norm, we're left with these statutes that really don't give fathers, at least from the onset, any rights out of the gate. Now, I'm not a men's rights lawyer. I'm not a women's rights lawyer, but I just want to be clear that that is something that I would foresee changing in the not too distant future. Which takes me to a third prediction about the next 10 years or so, and that's this: that the definition of family is changing, has changed, and will continue to change. And one of the cutting edge issues involved with that change involves the number of parents that a child may have as a legally recognized parent. If you ask 100 people on the street, how many parents does a child have? Typically the answer will be 2. But that norm, that way of thinking, has been challenged legally over the last 10 to 15 years. And I had the privilege of challenging that norm here in the state of Minnesota very recently. And did so in a case that I've kind of labeled as Lexi's case. So let me share with you a little bit about that case and kind of walk you through what this journey has been like. For those of you that are in remotely, we know that you're there. There's a number of people who are here by webinar as well. The slides will be made available for everybody after the presentation today. So with regard to this case that I've deemed or called Lexi's case, some basic facts to be aware of, and I want you to kind of hang with me a little bit because it's a little confusing, but at the same time it's inspiring. Lexi Schlegel is a child, a young lady, young girl, who was born on April 24th of 2014. And she'll be 6 years old in the not too distant future. Lexi's biological mother was a woman named Rebecca Schlegel. And her father, biological father, is and was a man named Cody Demo. The facts from there start to spiral out of control a little bit. Mr. Demo was imprisoned in September of 2016. Lexi was born to her mother, Rebecca, when Rebecca was underage. And Mr. Demo was the father of Rebecca. Mr. Demo was convicted of criminal sexual misconduct, not in cases or a case involving Rebecca, but in cases involving some other minors. And as a result, he had been imprisoned for a pretty long period of time, although I believe he's now out of prison. The most tragic part of the fact scenario here is that Rebecca died tragically in a car accident in May of 2018. She was just 20 or 21 years old at the time. It was a foggy morning. She was alone in her vehicle. She lived in the Brainerd area, but to characterize where she lived as Brainerd really doesn't do it justice because it's rural Brainerd, and rural Brainerd is kind of the middle of nowhere, kind of between Brainerd and Lake Mille Lacs. There's a lot of farms, there's a lot of hunting property out there. So she was involved in this car accident, died at the scene, and as a result, left Lexi without a surviving mother. Now I want to take you back to Lexi's mother, Rebecca's family history. She was born to a gentleman named Bob Schlegel and a woman named Jennifer Wild. Bob and Jennifer were married when Lexi was born. I'm sorry, when Rebecca was born. Rebecca was born when Mr. Schlegel and Ms. Will were also relatively young. And so when you talk about a grandparent adoption, a four-parent adoption, quite often the thought that comes to mind is someone who may be a little slow-moving, perhaps retired, and that's just not the case. In fact, Bob Schlegel and Jennifer Will are in their early 40s. But as a result of them having Rebecca when they were young and Rebecca having Lexi when she was young, they're grandparents when many are still parents and raising children themselves. So back at the time that they divorced, they were exercising parenting time with Rebecca on a week-on, week-off type arrangement. And they did that for years, and it worked extremely well. During that time, after the divorce, Bob Schlegel, hang with me now, biological father to Rebecca, marries Jill Schlegel. And Jill is the woman who first contacted my office last year. Jennifer Will, again, Rebecca's biological mother, also remarried a gentleman named Ronald Will. And so I've outlined for you kind of graphically what this family tree looks like. The yellowed names are of biological relationship. And then on each side of either Bob or Jennifer are Jill, which is essentially Rebecca's stepmother, and Ronald, who's Rebecca's stepfather. Okay, so Mr. Demo, Cody's parents are not involved in this particular family tree. They had not established any kind of a relationship with Lexi. nor is he involved in this family tree because of the fact that he was incarcerated, but also the fact that, as you'll soon learn, he ultimately was willing to sign off on his parental rights. So what we're dealing with here is a four-parent, four-grandparent situation, but the grandparents are basically on the maternal side only. Those that remain in the Demo family don't have any role to play, or had no role to play in Lexi's upbringing. In meeting with this family, I came to learn something really, really interesting as far as what their perspective was in raising Rebecca, and that was that they wanted to create one world for Rebecca. And that resonated with me, and it's a concept that I've heard actually repeated a couple of times from other sources in my practice over the last year or so. Maybe it was uttered before and I just didn't catch it, and it resonated with me at the time it was said now, and so it comes to mind. But this concept of one world, this idea that kids, despite the fact that they are living in separate households with separate parents, with separate rules, separate norms, the idea is that that child should have the right or the ability to live sort of cohesively or in harmony with both sides of their family. And the traditional idea, the traditional notion of family court outcomes is that, you know, kids bounce from one house to the other, where there are incidents of friction, where there's disrespect between one parent and another. And so from just the standpoint of the Schlegels and the Wills, the fact that there was initially a divorce between Rebecca's parents, and they cared enough to want to create one world for Rebecca, where Rebecca would go week to week, one house to the other, I think was just a refined example of how good can come from parents living in separate households. The interesting thing is that they're both farm families. They have large plots of land up in north central Minnesota. And as a result, when I've been up there to visit with them, you know, you could see that it's sort of this, it's almost magical area where 5 miles down a dirt road, you know, there's one house and another, and Rebecca was just sort of able to transition seamlessly between the two. Interestingly, when Lexi was born, Rebecca was 17, and she continued to live with her parents week on, week off. And so as a result, by default, Lexi was also experiencing this one world concept, where Lexi would go from one set of grandparents' home 1 week with her mom to another set of grandparents' home the next week with her mom. And so there was nothing foreign about, you know, what was to come in terms of what we were asking the court to do, and nothing foreign to Lexi about living in harmony with both sets of grandparents. So these four individuals become guardians of Lexi after the car crash in June of 2018. And they petitioned for guardianship up in Crow Wing County. For about 9 months, that process sort of unfolded. And ultimately, they continued to care for Lexi, again, these four grandparents, caring for Lexi week on, week off, keeping things as normal as possible for her. And so after about 8 or 9 months, they started thinking about adoption. And they thought, well, you know, how is it that we can continue to, honor each other in a dignified way and recognize that we all have a crucial role to play in this child's upbringing, and B, honor Rebecca by not leaving open the question of where will Lexi, you know, wind up. But adoption involving four parents is something that hasn't really happened much, if ever. And so ultimately, biological father, Cody Demo, indicated that, yeah, he's on board, he will agree, and he will allow this adoption to take place. And so, Jill Schlegel calls my office. And I'm sitting there, and it's about 10 to 5. I was ready to go home. Phone rings, and I pick it up. Didn't really want to. I thought, oh, I'll answer the phone. You know. And we spent about a half an hour on the phone talking to each other. She shared all this information with me. And she shared with me that she contacted a number of attorneys in the Brainerd area and was interested in pursuing a 4-parent adoption. And I said, okay, tell me more. And she, proceeded to explain kind of this family history and said, so what do you think? I said, well, I don't know. There's a movie, maybe you've seen it, The Mule with Clint Eastwood, where he says to someone in the movie that their generation can't open a fruit box without dialing up the internet. Well, the first thing that came to my mind is I'm going to just dial up the internet. I'm going to try to find something out there that tells me that there's guidance on this one way or the other. The ultimate question being, can 4 parents adopt a child and establish a parent-child relationship? And so I told her I would do that, and I told her I'd call her back. And she said, okay, well, sounds good, give me a call back. And so the first thing that I was able to unearth after looking for a time was a really well-written article by an adoption lawyer who practices in South Carolina. And her name is Colleen Quinn. And she wrote this article about tri-parenting arrangements and what statutes, what published cases would support the idea that more than 2 individuals can establish a parent-child relationship with a child. And her article began by offering sort of an overarching view of, how things have changed with increasing use of gamete donation, surrogacy, recognition of same-sex marriage, other factors in society. The world is facing what she calls a new frontier in family formation. And it's true. I mean, the norms that may have been in place 25 or 30 years ago are rapidly being deployed. And that's a product not only of technology and things like easy access to DNA testing itself, but also the recognition of relationships besides those that are just landing within the traditional definition of a marital relationship. One of the key issues that she points out that exists on that sort of new frontier is the question of, can there be a recognition of more than 2 legal parents? Now, in the context of a parent-child relationship, and in looking at family law generally, it's important to understand that parent-child relationships exist generally in 2 to 3 to 4 broad categories. There are categories that involve technology, like alternative reproductive technologies, things like artificial insemination and donation, things like surrogacy arrangements. There are also relational aspects to a parent-child relationship. By definition, a presumed parent, if one is married, to be the parent of a child. In addition, there is paternity testing. There's a whole host of statutes that apply in the paternity arena, and of course there's adoption as well. Now, coupled with, this is just kind of big picture stuff, but coupled with the different ways that a parent-child relationship can be created, there's this wide spectrum of types of relationships that a person can have with a child. You can be in a parent-child relationship and have all the rights and responsibilities that go with that. But you can also have custody of a child, which gives you a certain number of rights, but maybe not all rights. You can have the right to parenting time, the old school version of visitation, right? Parenting time. And sometimes that means grandparenting time. You can have the ability to be a parent but not have parenting time and not have certain responsibilities or the privilege of playing a role in decisions. And so one thing that's really important to understand is that in dealing with this issue of can there be more than two parents in a situation, the question often is framed by courts in terms of that spectrum of, well, we're not going to go so far as to say, yes, there's a parent-child relationship. They might say you have a right to parenting time. You might have the right to custody. You might have the right to make certain decisions for a child, but you may not have the legally sound established relationship of parent and child, where one's name is placed on the birth certificate of that child and where certain rights are vested. I tell clients pretty regularly that there is no more sacred relationship within the court system, and all of us know in real life, between that of a parent and child, right? There's no more protected relationship that can exist. And so some people are aiming for that, wanting to have that protection, wanting to have those rights, but also have that responsibility. So with regard to the alternative reproductive technologies, in family law world, we call that the arts, okay, alternative reproductive technologies. In those arrangements where one approaches another individual and says, help me have a child, there are typically several players in that. There are the intended parents. Those are the individuals that are seeking to have a child. There are donors, those that offer their genetic material. And then there are surrogates, those that hold a child, right, in utero and give birth. And the norm thus far has generally been that within the context of an art arrangement or a surrogacy agreement, that the sole focus of that agreement is on the rights and responsibilities of the resulting parents. In other words, most people historically have said, you know, I am willing to serve as your surrogate, but I don't want to have a relationship with this child. I don't want to have any responsibility for this child. And so if you are willing to relieve me of that obligation, I will help you. And as a result, there are like these surrogacy contracts and other agreements that are reached between the individuals to that relationship. But what's become more normal, albeit not yet normal, it's evolving, situations where someone is going to help another couple have a child, but all of the relevant parties plan ahead to have certain rights or certain responsibilities recognized by more than the two intended parents. And so you've got what Colleen has said is tri-parenting by design. Now that's not what we're dealing with in this adoption case. This four-parent adoption case is not an arts case. We're not establishing a parent-child relationship between Lexi and these individuals because of some alternative reproductive request. It's in the context of adoption. So again, there are multiple ways to establish that relationship, but just to provide broad context, the case law in this area has almost always involved some sort of alternative reproductive technology, and so we have to use that by analogy and apply it to the adoption cases that may come our way in the future, as we did in Lexi's case. As I mentioned earlier, beyond arts, parentage is also established in a whole host of ways. In addition to the changing technology and this plethora of ways to recognize a relationship, society has changed as well. There are increased rates of cohabitation, as I mentioned early on. There's now the legally recognized same-sex marriage. Divorce has become more prominent. Remarriage has become prominent. Polyamory. This is a relationship where willing individuals sort of live together, or, well, no, they don't live together, but they are in non-exclusive relationships with one another, and they do so by agreement. Of course, that opens people up to having a child with someone other than the person they're living with. And again, increased access to DNA testing, 23andMe, and the like. So what Colleen Quinn has said is that there are extremely limited situations where more than two parents will legally be recognized with that whole host of rights and obligations that a parent has as a legal parent to a child. She also indicated in this article that there are even more limited documented situations where more than two parents wind up placed on the birth certificate of a child. And she says this concept is going to evolve quickly and will trail the establishment of more than one parental relationship, or more than two, parental relationships with a child. But the big picture that I think is important to understand is that this really is something that is early in its course. And there is, some guidance out there, but not a ton of it. So I read Colleen's article. I read some of the cases we'll talk about here in a minute that were referenced in her article. I took a look in particular at Minnesota. I read the Uniform Parentage Act, and I thought about it for a while, and I thought, well, what are we going to do? I called them back and I said, it looks like, from a policy standpoint, that there is probably a movement towards this being something that would be acceptable. I said, I need to do some more digging, but let me take a look at it and I'll follow up with you again. She said, okay, that sounds good. So in that context, I was able to find that there are 4 states with statutory authority for a child to have more than 2 legally recognized parents. States of California, Maine, Washington, and Louisiana. So all over the map. I mean, from the West Coast to the East Coast to the South. In California, no secret, California is probably accurately portrayed as being pretty progressive. In cases where a child, this is what the statute says, in cases where a child has more than 2 parents, the court shall allocate custody and visitation among the parents based on the best interest of the child. And so there's a presumption under the laws of California that in black and white, a child can have more than 2 parents. Sort of imploding the traditional notion of you need, a sperm cell and an egg to make a child, and therefore you can only have 2 parents. In addition, there's a secondary statute that says that a court may find that more than 2 persons with a claim to parentage are parents if the court finds that recognizing only 2 parents would be detrimental to the child. And so the emphasis has never been on what's best for the potential parents, what's best for the litigants in the case. Like all statutes, like all custody statutes in particular, it's about what's best for the child. But here the burden is a little different. They will recognize it, but only if it would be detrimental to just have 2 parents recognized for that child, taking into account a whole host of potential relationships between individuals and a child. So fly to the East Coast, the state of Maine, its Parentage Act says this. And again, Parentage Acts are a set of statutes that apply to cases where a child is born outside of wedlock. The divorce and domestic relations statutes in Minnesota, for example, under Chapter 518, those pertain to cases where parties are splitting up, their marriage, and there needs to be a determination made about what is to happen with regard to a child. But there's a separate set of statutes that deal with the establishment of paternity, and there are certain presumptions about who is a presumed parent. For example, if a child's born within the context of a marriage, or within 285 days following the breakup of a marriage, the husband in that marriage is the presumed father of a child, right? Kind of makes sense. Now, that can be disproven, and someone else can come forward and make a claim that they're the father of a child, even though the child was born within the context of a marital relationship. But we're talking about presumptions. The Parentage Act in Minnesota presumes that if someone signs a recognition of parentage at the hospital, that they are the parent of a child. In fact, it's actually considered a formal adjudication of that issue if it's done. Interestingly, our paternity statutes in Minnesota also say that an individual is a presumed father if they have taken that child in as their own and held them out as their own child, even if they may not be their biological child. And so there's lots of different ways that courts are there to protect children, I think, to make sure that they have stability and continuity. And so when we're talking about Maine, the Parentage Act, it's in the context of a paternity, in a paternity case. Same is true in California. The code there combines paternity and dissolution actions, but again, backtracking a little bit, they just spell out, if there are more than two parents, basically assuming that that is to be the case in some paternity context. But we've got the Maine Parentage Act saying that. Washington, back to the West Coast. Now, what Washington has done, and this is what really sort of got my attention as I was contemplating what to do with Lexi's case. The state of Washington has adopted what is the newest version of the Uniform Parentage Act. That's the set of statutes, again, dealing with paternity. How do you establish a father-child relationship? The Uniform Parentage Act is like any other uniform act. The Uniform Child Custody Act, I suppose the Uniform Commercial Code, things like that, Uniform Probate Code. So a couple years ago, the Uniform Parentage Act was amended to specifically recite the fact that a child may have more than two parents. Minnesota is a Uniform Parentage Act state, but Minnesota has yet to adopt the newest version of the Uniform Parentage Act. But that act was approved, and so it seems that that is the direction that things are going. Here's what that Uniform Parentage Act says. It says the court may adjudicate a child to have more than two parents if the court finds that failure to recognize more than two parents would be detrimental to the child. So kind of mirroring the language from the Maine statute that's there, although Maine did not adopt specifically the most recent version of that Uniform Parentage Act. And then down to the south, Louisiana, in the context of paternity. Child has a right to dual paternity in a cause of action under which they can institute an action to prove someone is their father, even if another individual is the presumed father. So it's an idea where if someone holds themselves out as a child's father, but they're not the biological father, the court may adjudicate that father holding child out as parent, but the child at some point in their life would have the right to say, I want to establish paternity between myself and my biological parent, and therefore there can be three parents in that type of a situation. It gets a little fuzzy, but I hope I'm making that clear. And again, this is in the context of paternity. Recall, a parent-child relationship can exist either through the arts, where we have a contract. It can exist through paternity. It can exist through marriage. It can exist through adoption. In addition, in Louisiana, that biological father has the right to bring their own paternity cause of action, even if the child is presumed the child of another man. So not only does child have the ability to say, I want to establish this relationship, which would kind of be unusual if you think about it. It's more in the interest of the biological father who would want to say, yes, this is my child, and I have rights to this child, and I have the privilege of calling this individual my child. And so I'm going to do that despite the fact that a court has adjudicated another person your father. Felt like a Star Wars moment for a second. So in addition to statutes, there are these 4 states all over the map that have these statutes. That's it in terms of statutory authority. Again, we've got the Uniform Parentage Act kind of sitting out there saying, you know, yes, child can have more than 2 parents. Nearly every state, if not all states, are a Uniform Parentage Act state, including Minnesota, but they haven't embraced it yet, as it happened at the legislature. There are 7 states who have published decisions concerning a recognition of 3 parents, or 3 legal parents, or giving a 3rd parent significant legal recognition. Now, here's the difference. We talked earlier about the fact that someone on that spectrum can be given complete parental rights to a child. But then they can also be told, no, you're not going to be legally recognized as a parent, but we are going to give you custody. Or, as we'll see here, some courts will say, well, you're a psychological parent, you're an important person, but it still doesn't go quite as far as establishing that parent-child relationship. So here we go. Delaware, Louisiana, New Jersey, New York, North Dakota, Pennsylvania, and this is the big surprise moment in the presentation, Minnesota actually has a published decision on some of these issues. So we'll get to that in a little bit. The facts of these cases, if you have a chance, they're really interesting. I mean, what people decide to do in various arrangements in an effort to have a child together, it's interesting to say the least. So in this case, DG versus KS out of New Jersey, biological mother enters into a tri-parenting agreement with 2 men who were in a same-sex relationship. Her egg, one of the man's sperm, the other man's last name. And the agreement was upheld by the New Jersey, I think it was a Court of Appeals, may have been a Supreme Court case. In any event, the agreement was upheld, but, and this is important, with a denial of full legal parentage. Okay, so in New Jersey, they weren't willing to go so far as to say parent-child relationship, yes, all 3 of you on birth certificate. Instead, they've said, well, we're going to uphold your agreement. 2 of you are going to be parents. 1 of you is not a legal parent, but you're an important person in this child's life. And then they went on to say, you can do so through an adoption if you want to. And I don't know if they ever went through with the adoption. In Delaware, JWS versus EMS, this is interesting. An ex-husband, so this person was married to mother, and mother had a new lover, someone she was having an affair with during their relationship. Mother waits 4 years to tell presumed father of the other man. And so the presumed father, the ex-husband, is told 4 years into this child's life that you're not the father of this child. The other man wanted to be recognized as a father because he had that biological connection. The ex-husband had held that child out as his own and was basically told, you're the father. And in that case, this was the first time there was actually, and I've kind of italicized, recognized, both men were recognized as fathers, meaning that the court in Delaware did take that final step to say, yes, you're not just an important person in this child's life, someone they've relied on, but you are all 3 parents to this child. There are 2 fathers, given the ex-husband's active involvement in the child's life. North Dakota. You wouldn't think North Dakota would be a hub for interesting tri-parenting arrangement cases, but there was one, McAllister. There was a mother, a stepfather, and a biological father. So in this case, what we have is a stepfather who cared for a child during the marriage to the biological mother. Biological father was sort of absent and out of the picture. But the stepfather never went forward with any formal adoption. And in that case, when mother and stepfather divorced, he petitioned for custody and parenting time and wanted to have a parent-child relationship established between he and this child. And the court said, well, you're a psychological parent to the child. You can have parenting time, but they didn't take it any further. So again, we've got this collage of options that courts have exercised, and in North Dakota they did not go so far as to give the stepfather absolute parental rights. In New York, there was a case where there were two women, a man. They were in a polyamorous relationship, again, sort of living willingly with them engaging in sexual activity with one another. Man and the wife broke up. Wife seeks custody based on the caregiving, the fact that the wife was not the biological parent to this child, and that the mother with whom the man had the affair was the biological father. Both women were deemed, and this is what the court said, equal mommies, which it's unclear, I guess, to me whether that means there's a parent-child relationship or not, but it's, again, are they a psychological parent? Are they an equal mommy? It's almost going there, but not quite. Which takes us to Minnesota, which is what the Minnesota Court of Appeals did about 20 years ago. Now this case in Minnesota, I think we have the distinction of having probably the most complicated set of facts that led to a conclusion. So here we go. So there's a female parent whose last name is Mitten. She's involved in a same-sex relationship with Ohanian, okay? And these two women decide that they want to have a child together. They solicit or elicit donation from a friend, La Chapelle, who along with his same-sex partner agree to have a child together. At first, the agreement basically said there's not going to be any rights, any obligations, any relationship between donor male and the child, and he wouldn't have any parental rights or responsibility. But that changed about a month after conception. A new agreement was signed, a new agreement that called for the two men to have a significant relationship with the child. It gets better. La Chapelle and partner, the two men, they did exercise very limited parenting time after the child was born, but then almost immediately terminated their visits with the child. And so Mitten had a good idea, she thought. Without notifying the men, she and Ohanian would file a petition for adoption, suggesting that there was artificial insemination, but not revealing the identity of La Chapelle. And so the adoption was granted, but La Chapelle decided he was going to go back and get that adoption vacated based on fraud, which he did, and he started a paternity proceeding. And then Mitten and Ohanian, the two women, broke up, and all three, Mitten, Ohanian, and La Chapelle, claimed parental rights to this child. What a mess. But the Minnesota Court of Appeals, in a published decision, said that this tripartite arrangement was appropriate after considering the best interest of the child. The court determined that Mitten was biological mother, that La Chapelle was biological father, and that Ohanian, the same-sex partner to Mitten, was the child's emotional parent and someone that the child looked to for comfort, solace, and security. So Minnesota, at least as of 20 years ago, was on this brink of, yes, you can have a special relationship between a child and more than two parents, but didn't take it as far as saying there will be three parents to this child and there will be three names on the birth certificate. So physical custody to Mitten, to mom, joint legal custody to Mitten and Ohanian, the two women, and LaChapelle received the right to have involvement in important decisions. The interesting thing too is that in that LaChapelle case, both Ohanian and LaChapelle were both ordered to pay child support to Mitten. So throw that into the guideline calculator and see what you get. So that's what I've got on my desk, and I'm thinking, okay, I got some guidance here. The signs are there, right? It looks like this might be okay to do with a straight face. I called back the Schlegels and the Wills, and I said, you know, here's what I found. I said, what do you want to do? I said, you know, I can't guarantee, you can never guarantee anything to a client anyway, but I said, I can't guarantee you that the court will accept this. Our case was venued in the middle of central Minnesota. Thoughts ran through my head, no disrespect to folks in that part of the state. And if you're out there listening, you know, God bless you. But I didn't know if they would be as progressive in their thinking, perhaps, as Hennepin County has a reputation for. So I kept thinking, well, you know, we've got the right facts. Do we have the right venue? But something just said, yeah, I mean, we got to give this a shot. But ultimately, it was up to them. And so they decided that, yeah, they wanted to go forward. And we figured the worst that could happen was that the court would say, well, we're going to recognize the relationship between the two biological grandparents and Lexi, and then the others would just be sort of along for the ride. But again, this one world concept wouldn't have been fulfilled had that been the ultimate outcome. So we put everything together. We filed our materials with the court, and we made several arguments. The first was this: Minnesota is a uniform parentage act state, right? And as I've kind of shared with you this afternoon, the newest version of the UPA expressly includes that provision recognizing more than two parents. And so the first argument is kind of straightforward. We're going to be there soon. Just let the legislature catch up. But we're getting there, so why not just go there? The second argument is under the existing law in Minnesota, that there is no limitation under our existing laws to the number of parents that a child may have. In other words, the statute under that 257, the paternity code, says it includes a mother-child relationship and a father-child relationship, but it doesn't say only a mother-child relationship or only a father-child relationship. And so I thought, well, if it doesn't say I can't, maybe we can. One could argue, you know, thinking this through, that the statute mandates one mother, one father, but that argument would be shot down because same-sex couples have been allowed to adopt for a long time here in the state of Minnesota. So a child can, in fact, have more than one mother, right, and more than one father under our existing laws. The question is, can the child have more than two parents? One thing we thought was that perhaps marital status would be brought up. We thought that perhaps there would be a question, well, the Schlegels and the Wiggles the Schlegels and the Wills are not married, and so, you know, maybe this shouldn't happen as a result of more traditional thinking. And there was, again, nothing in the statute that prevented that. The adoption statutes say that a parent-child relationship can exist regardless of the marital status of the parents. And nothing in the statutes limits the number of parents who can adopt a child. It's only established by proof of the actual adoption. One other thing that we argued was this, that the adoption statutes apply directly by analogy. And here's what we meant by that. Minnesota courts recognize that adult adoptions can exist. I've had cases where a 20-something man or woman, come in and they say, I want my stepdad to be my dad. I want to move forward and have an adoption as an adult. And, that is something to be celebrated. But the fact is that in doing it that way, instead of when a child is a minor, you don't have to terminate the parental rights of the biological father. If a child is young, the first step in a step-parent adoption is to get the biological rights of the rights of the biological father terminated, either by agreement or by court order. That opens up the adoption. So what we said is that in every adult adoption in the state of Minnesota, absent some need to terminate parental rights, the adoptee is left with 3 parents anyway. And of course, we argued La Chapelle. We said that in that case, the court affirmed. The lawyer who represented Mitten in that case, is a very good lawyer, argued something that I think just, it's really well written, although I think it kind of goes a little overboard. She argued that the district court created what she called an impermissible triumvirate parenting scheme. But I had to laugh because these parties did this to themselves. Court of Appeals affirmed. And so ultimately, in Lexi's case, we were successful. We were able to get that adoption granted. And all 4 of these parents, all 4 of these grandparents now appear as parents on the birth certificate. From a logistical perspective, we didn't know if the state would have more than 2 spaces in its database to be able to put that on, but they worked with us and got that accomplished. So that's good news. What I would like to do is take a moment. I'd like you all to kind of meet this family because their story is one that has inspired me, the fact that they got along so well, the fact that they have created this sort of one world concept for Lexi. They really can serve as an inspiration to parents who are out there who argue about things that are far less serious and show how you can react in the worst of circumstances to bring out the best for purposes of a child. So I'll go ahead and hit this and then we'll wrap up. All right.
First, an adoption involving 4 parents.
Ellen Gallagher went to Brainerd to bring us this story about how families can come in all shapes and sizes.
What's your adoption name?
Yeah, of course, yeah. There's an expression. When you lose something precious, you sometimes gain something priceless.
She reminds us of her mom. Every second of every day. Her looks and her laugh.
5-year-old Lexi Schlegel's mom, Becca, tragically died in a car accident in May of 2018. She lost her mom, but she gained 4 parents.
We work well together.
Lexi has 2 sets of grandparents on her mother's side due to remarriage. This summer, all 4 petitioned to legally adopt her and share custody with the consent of her biological father.
I'm still her Nana. I'm always going to be your Nana because Becca's always going to be her mom. But if she wants to call me mom, that's okay. We always tell her, you always have your mom in heaven. We're never going to replace her and promise you just to make sure that she never forgets her mom.
Yeah, that's it. 4 grandparents who are now legally her parents as well. Not to mention a host of new older brothers and sisters who are also aunts and uncles.
She's got 7 great grandparents that, at the drop of a dime, will come and do anything for her.
These 2 sets of grandparents live about 10 miles apart.
Whose head is this?
Lexi has her own bedroom in each home and splits her time evenly in each one. And the more we say, they make a good team.
If Lexi does something cute or whatnot, we'll snap each other a picture and send it back and forth.
They even all work together to build this playhouse to honor her mom's birthday. It might seem complicated, but actually, it is really quite simple.
You have lots of people to take care of you, right? Yeah? Doesn't matter what your family looks like, it just matters that you love, your kids and the ones that you're taking care of. And Lexi's definitely very loved.
And this is the first four-parent adoption ever in the state of Minnesota. Nearly 20 years ago, the Minnesota Court of Appeals first acknowledged three-parent arrangements, but legal experts say cases like this will become more common as the traditional family continues to change and evolve. Reporting in Brainerd, Minnesota, Ellen Gallis, 5 Eyewitness News.
So that's the Wills and the Schlegels and Lexi. I have to say that the judge who was assigned to our case is one who was extremely thoughtful, who asked a lot of very good questions about if and how and why, and she is really one of a few people to thank for improving the life or sustaining the life of this young child, because no one knew, what was to come in the event that the request was denied. So that said, if anyone has any questions, I would be more than happy to take those. And just to let those that are appearing remotely know, if the video quality was not good coming through on the story, the folks here at the Supreme Court building are going to send out a copy of the file so you can watch it there. Or you could go to KSTP, their website, and just search the word Brainerd, and it shows up on about the second page. So with that, does anybody have any questions? All right. Thank you again. I appreciate your time. I know you're busy. So have a good day.